Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Lyles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Personal Care Audits and Enforcement in Texas. Our presenters for today are Ashley Morgan and Alexander Naum. Ashley Morgan is a partner in Lyles Parker's DC office. Ashley focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connection with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion and termination issues. She has worked with an assortment of providers, including home health companies and hospice agencies. Ms. Morgan is also a certified professional coder, a certified medical reimbursement specialist, and the certified medical compliance officer. As for Alexander Naum, he is a law clerk at Lyles Parker and a recent graduate from the American University of Washington College of Law, where he obtained his healthcare compliance certificate. Alexander has experience working with the Centers for Medicare and Medicare Care Services, where he reviewed and provided recommendations related to program operations. Alexander has experience assisting with cases related to False Claims Act and other healthcare fraud and abuse statutes, along with proficiency in assisting with trademark filing and appeals. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. We will also be sending out a copy of the presentation tomorrow. So without further ado, I present to your speakers, Ashley Morgan and Alexander Naum.
Thank you so much, Gio. You can click to the next slide. So, as a general disclaimer, this outline is provided as general information only, does not constitute legal advice, and should not be used as a substitute for seeking legal counsel. Outcomes may differ depending on specific facts. We can move on to the next. So this is just a general outline of what we'll talk about today. We'll discuss what can trigger a personal care audit, the Texas OIG audit and inspection plan for 2025, an overview of the False Claims Act, an overview of the anti-kickback statute, some recent enforcement trends, and tips when responding to an audit or investigation. Can we go to the next slide? All right, here are some of the common areas that can trigger a personal care audit. While it's not an exhaustive list, surveillance of these should be a compliance priority for all personal care organizations. So some of the things that we'll kind of dive into include, services billed without supporting documentation, services billed that are ineligible for reimbursement, services provided without the required supervision, which definitely requirements vary state by state. Services provided without state verification of qualifications, services provided during an institutional stay, and of course, fraud, waste, and abuse. And we can go to the next slide. So before submitting a claim to Medicaid or any other payer, you must ensure that you're providing supporting documentation that tests to the services provided and the applicable requirements are met. This includes providing the dates and hours of the services provided, and it also, really important, federal law requires that all healthcare records be kept for a period of at least 6 years from the date of creation. And again, dealing with an audit is already stressful on its own. You don't want to create further issues for your organization as a result of premature destruction of records. So it's really important that you keep all records for at least 6 years from the date of creation. And another big thing, in the eyes of the government, claims without supporting documentation are considered overpayments. And if the government identifies a pattern of, lacking of supporting documentation or, lacking specific areas within the documentation, that can trigger an audit, which we definitely want to try to avoid. So go to the next slide, please. Okay, so you may need to make sure that the services, you need to make sure that the services that you're billing are actually eligible for reimbursement. you should make sure beneficiaries are being billed for services that are actually, I'm so sorry about that. You should make sure that beneficiaries being billed are actually eligible for payment by a specific payer. You must ensure that you're providing and billing for services outlined within the plan of care, and you should never bill for services that you provide to other beneficiaries, to other members of the beneficiary's household. So again, you want to ensure that you're only providing support to the specific beneficiary. You really want to kind of like stay within there. I know it can be really easy to also provide support to other members of the household, but again, you really want to make sure that you're focusing on the beneficiary and only billing for the beneficiary. And then another big area too is, work provided by specific intendants that are not verified within the state qualifications, the specific qualifications that each state requires. And also you need to remember that even covered services may be subject to limitations, so always stay up to date to changes in requirements. Let's go to the next slide, please. All right, so here's an example of another area that is really, really important as well. Texas Administrative Code requires that a supervisor visit to review the work of the attendant and assess whether the care being provided to the beneficiary is sufficient. Texas requires that the supervisor document on a single form whether the care provided is adequate, the need for continued care, if there's any changes that need to be made, and the competency and efficiency of the attendant. Texas requires that these visits occur at least annually. However, depending on the beneficiary, it may be more frequent. So again, that would all just be dependent on the plan of care that is outlined for that specific beneficiary. Let's go to the next slide, please. All right. So one of the big things which we talked about previously as well, you need to make sure that your specific attendants that you have and also the supervisors as well are meeting the state's verification requirements. So for supervisors, so it's both supervisors and attendants. So supervisors must be properly trained by a provider to ensure proper understanding of the rules and procedures of the TAHC program. For attendants, there are other requirements. They cannot be the legal parent, foster parent, or spouse of the parent of the minor receiving services. So that's in the cases of minors. For the cases of adult individuals, they cannot be the spouse of the specific adult beneficiary. And then in addition, attendants cannot be on the do not hire or any exclusion list. So definitely when you're hiring, you need to make sure that you're checking the exclusion list and you're checking all the various different do not hire lists and ensuring that the staff you're bringing on board are able to be billed under the public programs. Finally, all attendants must be provided with an orientation outlining the beneficiary's plan of care, and that specific orientation must be documented on file as well. Enforcers are really looking at that. So you want to really make sure that that's being documented and you're following the rules that are specific for that. Let's go to the next slide, please. Okay. So some states also have additional requirements as related to background checks. We've discussed the exclusion list, but there's also some states that require, that you check the nationwide criminal background history of the specific, attendant that you're bringing on board and making sure that they're not within, flag at all within any criminal history. As well as also reviewing the specific abuse and neglect registries as well that exist. And then some states also put on other different requirements as well. There may be restrictions based on age, health status, and there may be other specific requirements related to the education and training of the attendants. So definitely, you always have to make sure that you're checking the requirements of the specific state, the Texas requirements, of course, we're talking about Texas. But again, you want to keep, an eye on changes in those requirements because they may change depending on new regulations that come out. So next slide, please. So a big thing, the government, it's like very big on most federal and state regulations. Personal care services are not covered when a patient is checked into a hospital, a nursing facility, mental health facility, or intermediate care facility for those with intellectual disabilities. And that is unless there's an approved waiver provided. And again, you want to make sure that if you are engaging that, you want to make sure that you get those waivers approved prior to providing care, and also just definitely ensure that all the requirements are met under those specific waivers if that is what you're seeking. The thought process of this is that the staff of these inpatient facilities are already providing care to the beneficiary, and parents don't want to pay for the added on care. So again, you just really want to make sure that you're following the specific rule. Okay, next slide, please. So the government wants to prevent fraud, waste, and abuse in personal care. Some common examples that are on the government's radar include, offering medically unnecessary services, which we touched on previously, offering more services or staying longer than outlined within the plan of care, providing services by uncertified attendants, delivering services to ineligible recipients, forging credentials, billing for services not rendered, or submitting claims provided by an excluded individual. Understand that no organization is perfect. Billing errors are bound to occur. However, PC service providers have the duty to identify and disclose the errors when they do occur and provide any payments as a result from the error, repay those payments back to the government. So again, no one's perfect, but definitely be sure that you're, fixing any errors that happen when they do occur, and then repaying anything that was overpaid. All right, we'll go to the next slide, please. All right, so here is, some of the specific areas that the Texas OIG has kind of outlined within their plan for the 2025 year. Provider practices that are being reviewed in these audits include cost reporting, improper discharge, transfers to emergency room, and reporting of refunds, overpayments, and recoveries. So definitely, keep these on your radar, as well as within your compliance surveillance. Let's go to the next slide, please. And so just kind of continuing on some more areas where they're looking at. Provider audits will be assessing, Texas statutes, rules, and guidance, as well as contracts governing the client care and billing practices. Providers they're prioritizing include centers for independent living, home and community-based services, behavioral health, and long-term care. So we can go to the next slide, please. This is a specific branch of enforcement that monitors Medicaid fraud, and it's known as the Medicaid Fraud Control Units, also known as MFCUs. So here I'm saying MFCUs throughout this presentation, just understand that's what we're referring to. In Texas, the Texas Office of Attorney General has a specific MFCU that works in conjunction with the Texas Office of Attorney General's Healthcare Program Enforcement Division and the Texas Health and Human Services Office of Inspector General, which we may refer to as OIG later in the presentation. And their big, role is to investigate and prosecute fraud, waste, and abuse occurring in Medicaid-funded entities. In addition, federal enforcers may get involved, if federal law is implicated, And this may include, HHS Office of Inspector General, which often very much collaborates with various state MFCUs on fraud cases. And we can go to the next slide, please. All right, so we're going to dive into the False Claims Act. So under the False Claims Act, it is a crime to knowingly present or cause to be presented a false or fraudulent claim for payment or approval. And it's important to understand that this is not a specific intent statute. The government does not need to show proof that the provider intended to defraud the government. It's also important to understand that FCA claims are often driven by whistleblowers, who receive a portion of the recoveries, which those whistleblowers could be your current employees, your ex-employees, they can be your business partners, your patients, or even competitors. So it's always really important to have a positive relationship with your employees, as well as a lot of just various compliance guidelines, as well as like internal reporting procedures, and an opportunity to have your employees communicate any compliance concerns that they see, and so that you're able to address them and prevent any potential whistleblowers from occurring. In addition, something that's really important to understand is that healthcare compliance with healthcare laws and regulations are a condition of payment under the False Claims Act. For example, if a claim violates the anti-kickback statute, it is also rendered fraudulent under the False Claims Act. So it's really, really important to always just be in compliance with the various laws and regulations surrounding your practice, just to prevent any pulling in of the False Claims Act, which in the next slide we'll go into penalties, that you can face under the False Claims Act being implicated. If we can go next slide, please. So here are some of the penalties that can happen for violating the False Claims Act, which can be very, very steep. With fines up to 3 times the program's loss, plus penalties ranging from $13,508 to $27,018, and that is per claim filed. So you can imagine that these fines can add up very, very quickly and can be super crippling to any organization facing these types of penalties. And on top of that, additional criminal penalties and fines can also be added onto that. And one of the biggest fears from a lot of these too, is also being added onto a federal or state exclusion list, which would prevent a specific provider from participating in the federal and state healthcare programs, which is really just like the coffin and nail and something that you just really, really want to avoid. So again, it's just another reminder to maintain a good compliance program and prevent any of these from occurring, or the False Claims Act from being implicated. And now I'll pass the presentation on to Ashley, who will discuss the anti-kickback statute.
Thank you, Alex. So we're going to get into the anti-kickback statute, which Alex indicated many times. Anti-kickback statutes are now brought in conjunction with False Claims Act statutes. You can essentially piggyback a False Claims Act case from a anti-kickback statute violation. I did want to note one additional thing about whistleblower cases, which are known as KTAMs under the False Claims Act, is that a lot of times we see that when these cases are brought against providers, these aren't necessarily people who are just habitually out there looking to bring False Claims Act cases against providers. A lot of times these are people who have worked in compliance or have worked for a company for a long time, and they've tried to bring their concerns up to the company, and they feel that the company isn't addressing the concerns or is ignoring the concerns, so then they feel helpless and don't know where else to go. So it's really important that you as an organization, as Alex said, allow opportunities for people to disclose concerns, make an opportunity for them to be able to do so either as themselves or anonymously, so people can disclose that information and so that you can investigate it and, essentially paper what the resolution was of that concern, so that your employees feel like they're being heard and that their company is trying to be compliant, and isn't, ignoring their concerns and just worried about, making the most money possible, which, could be a violation of the False Claims Act statute, potentially, depending on what they're doing in order to make that money. So, it is important that you are allowing your employees an opportunity to be heard, so that they don't feel like they're out of options and do need to file a claim against your company. The anti-kickback statute. Under the anti-kickback statute, it is a crime. It's a criminal statute to knowingly and willfully solicit, receive, offer, or pay any remuneration, which essentially means anything of value, in return for referring or arranging for services payable by any federal or state healthcare program, or purchasing, leasing, ordering, or arranging for any goods, facilities, or services that may be paid for in whole or in part by any federal or state healthcare program. It's important to note that, again, this just applies to, Medicare, Medicaid, TRICARE, federal and state healthcare programs. There are many states that have their own corresponding programs as well, but these statutes do not apply to commercial payers, for example. They apply to federally funded programs. So that's what we're looking at, Medicare, and specifically for personal care, we're looking at Medicaid, because that is partially funded federally. And then again, if the state has a corresponding statute, then they can tack on state violations as well. But essentially, under the False Claims Act, essentially anything that in the normal course of any other industry, any other business, thanking somebody for referring a client to you, that is a violation of the anti-kickback statute. There's no de minimis amount under the anti-kickback statute, so technically anything, any sort of, lunch, anything like that can be considered a violation of the anti-kickback statute. Do we see a lot of prosecutions just based on a single lunch that occurred? No, not necessarily, but it is important to know that there is no de minimis amount, and to even offer to actually, provide this alleged kickback to somebody is a violation. You don't actually have to go through with providing whatever remuneration you said you were going to provide. Just the mere offer is technically a violation under the statute. And also, under the Affordable Care Act, it is no longer necessary for the government to show that the person had actual knowledge or specific intent to commit a violation of the anti-kickback statute, so it makes it easier for the government to bring these sorts of cases against people. It is also important to note that, while we know that healthcare companies are the ones that are being pursued in most times in a healthcare investigation, the Department of Justice has indicated that they're not necessarily going to just let the officers who are operating those companies go without any liability. They've essentially said that we know that there are people who are operating, within these companies that are committing the fraud, and that the company itself is not, just committing the fraud without the people under it. So you are not simply free to hide from liability under these statutes by operating through the company. They can go after the owners personally as well. What are the penalties under the anti-kickback statute? They can be pretty substantial. There is a sentence of up to 10 years in prison. Again, it is a criminal statute. A fine of up to $100,000. Exclusion from participation in the federal and state healthcare benefit programs, which really is just the death knell. You can't even volunteer somewhere. You can't volunteer at a grocery store, because grocery stores have, prescription drug programs where they're receiving money from the federal and state healthcare programs. It makes it really difficult to have a job, if you are on the exclusion list. It makes it very, very hard to operate. In addition to civil monetary penalties of up to $50,000 per violation, and assessments equal to not more than 3 times the amount of remuneration paid under the arrangement. Most courts have adopted an expansive reading of the knowing and willful intent standard under the federal anti-kickback statute. For example, under U.S. versus Greber, the Third Circuit adopted a one-purpose test and said if the payments were intended to induce a physician to use cardiomed services, the statute was violated, even if the payments were also intended to compensate for professional services. So even though they're intended to pay for the professional services, if they were, in one part, one purpose of that payment was to induce the physician to use the services, that they're considering that a violation. So again, they're making it easier to hold companies and individuals liable under the Anti-Kickback Statute and the False Claims Act. Next slide. Thank you. So this is a visual for you all. This is the nationwide Medicaid Fraud Control Unit, the MFUCU, their annual report for fiscal year 2024. This is where we got this information. The civil settlements and judgments for 2024, there were 493 total. There were 1,042 individuals that were individuals or entities, that were excluded. And you can see that the total money recovered was 1.4 billion. And if you look at the pie chart on the screen, you can see that a significant amount of that 1.4 billion were criminal prosecutions, criminal recoveries. So again, the MFUCUs are really looking at these cases. They're really looking at, there's a lot of personal care agencies out there that are being looked at. They're doing audits. Those are getting referred to the MFUCU. The MFUCU is prosecuting these cases criminally. They will certainly go after people criminally, and they will get the money back. It's a very real thing that's happening, and we have seen a lot of enforcement, especially in Texas, looking at personal care injuries, personal care companies, both on the civil side and on the criminal side. So it's a lot of money. They're worried about fraud, and they are going to be looking very closely at your documentation. So you need to make sure that your documentation is up to snuff with the coverage requirements, and that any contracts you have with any employees, vendors, 1099s are, meet the safe harbors of the Anti-Kickback Statute. Next slide. So this is another chart that we have for you of the MFUCU's criminal fraud convictions in 2024. So there were 1,151 total convictions. A majority of those were related to fraud, 817, and the others were related to patient abuse or neglect. A majority of those fraud convictions were related to personal care services attendants. And if you look at the chart that we have here, you can see the PCS attendants are down at the bottom. Significantly higher amount of fraud convictions by provider types for PCS attendants. So obviously the government knows this is a big area for fraud. They're going to continue to look and to try to ferret out fraud in the personal care industry. We have just continued to see an uptick in this area. So it's very important that you are being compliant. You can see, home health agencies have historically been heavily audited. And you can see that's significantly less than the PCS attendants. Next slide. So here is another example for you all. This is between years 2015 through 2024, the MFUCU criminal fraud enforcement trends nationwide. And here you can see that the darker red is personal care services attendants, and the lighter red is all other provider types. And these are the criminal fraud actions that are being taken against PCS attendants versus every other type of healthcare provider. And you can see it's almost half, and it's been that way since 2015. So it's consistent that the government is looking into personal care services attendants specifically, and finding fraud and prosecuting those cases. So, this shows that it's been continually a concern for them, and it will continue to be. And we continue to think that this will be a heavily investigated area by the government, just based on these numbers alone and the amount of fraud that they're finding and they are prosecuting, and the recoveries that they're getting. Next slide. Texas enforcement for 2024. So the Texas MFUCU received 2,061 referrals in 2024. Those referrals can come from a variety of different places. For example, it could come from a Medicaid managed care company. Could do just a regular audit of a provider. For example, Superior could send you a records request and do an audit. They could send their findings to the Mafuku. They have meetings where the government gets together with the payers and they all talk about what they're seeing. They could refer that case over to the Mafuku for a fraud investigation. The Mafuku also receives referrals from patient complaints. They receive tips from the OIG if somebody leaves an anonymous tip. They receive, board complaint issues. So it can be a wide variety. They also do their own investigations as well. But they receive information from a wide variety of sources. And you can see 2,061 Texas Mafuku referrals just in 2024. There were 219 Medicaid providers that were excluded last year. So that's a large number of Medicaid providers who are now no longer able to touch healthcare in any capacity. There were 74 provider criminal convictions in 2024. Again, they're heavily going after providers criminally for personal care, as we've seen in the prior slides. So, that's something to really be considerate about. That these aren't just civil cases; they're criminal. The total amount that's been recovered by the Mafuku in 2024, $120,771,680. That is a lot of money. They like to put that in reports to show, how much money they're saving the taxpayers by doing these investigations. And that's significant. And showing that amount of fraud out there, they're going to continue to try to have more recoveries next year. The total amount recovered by enforcement coordination, so that would be the OIG, the Mafuku, and HPED together, $606 million. So very significant dollars that we're talking about here that are being brought back in through these investigations. Next slide. So now we have some examples of some investigations just to kind of take all of this information, all of the laws and background information, and to show you some real life examples of things that have happened to other agencies around the country. So the first one we have here is an Ohio Personal Care Agency. This is the credentialing issue. So Ohio auditors reviewed and tested 6 personal aides that were employed for first aid compliance, determining that none of them were properly certified as they were required to be. The auditors then expanded their review and determined that an additional 12 aides were not properly certified. The auditors then discovered that the required first aid certification was not a requirement in the company hiring. So the company was failing to even make that a requirement for their employees. The auditors also discovered more errors. A lot of times when they start out an audit, they'll just pick at a single issue and then they can expand the audit because they think if you're not doing one thing right, what else is going wrong? And it makes their case stronger. So they discovered additional errors and many other claims submitted, which included that the services were submitted for payment prior to the physician signing a plan of care. The physician signatures on the plans of care were not dated. The lack of plan of care, wasn't even provided. They didn't have one to provide, or that the plan of care did not authorize the services provided. So lots of plan of care issues. And I know that those, hearing those, they sound really technical. And I'm sure the services were, the services were provided. I'm sure the services were great, but when you're receiving federal dollars and there's a requirement that something needs to be signed before it's submitted for payment, that's a really easy thing for the government to ding you on, and they will. They absolutely will. That's a requirement for coverage and payment, and if you're not doing that, it's going to cause a big issue later on. This agency ultimately faced a $2.1 million penalty for the violations that were identified through this specific audit. Next slide. This is the Virginia Personal Care Agency. Over a span of a 4-year period, approximately 7,800 fraudulent claims were submitted to the Virginia Medicaid program. Management at this personal care agency directed its employees to alter office records, including home health aide timesheets, as an attempt to conceal their behavior. One of the worst things you can do after you find out about an audit is go in and alter records. That takes you from being not in compliance to straight out fraud. That's one of the worst things you should never do that. We always tell providers that are being audited that we want our records to be as complete as possible. There are appropriate ways to make addendums to notes, but they always have to be signed and dated. the date that the addendum is made, and the addendum has to be obvious from the original entry that was entered. So it is never appropriate to alter your records to make it appear as if they always existed in that capacity. That is fraud. And that would take this case out of what could have potentially been just a standard audit to a fraud investigation. Here, the husband and wife management team were subsequently charged with healthcare fraud, false statements related to healthcare matters, altering records, and aggravated identity theft. We see a lot of times that identity theft can be thrown in on these cases because you're essentially utilizing a beneficiary's number to receive government monies. So they can ding you on identity theft for that. This case was investigated by the FBI and the Virginia Attorney General's Medicaid Fraud Control Unit, the MFUCU. Again, every state has a MFUCU. The husband in this case was sentenced to 63 months in prison, while the wife was sentenced to 25 months in prison. And they were also forced to pay close to $1.5 million in penalties due to the fraudulent conduct. So very significant, a very significant case here. You know, that's a very large sum of money, and the prison time is very, very significant here for these two individuals. And likely that was all related to, you know, altering those records. Next slide. DC, Washington, DC, where Alex and I are sitting today, personal care agency. An excluded nurse in this case used a fake name and forged several signatures to obtain a Medicaid provider number for a personal care agency. Over the course of 4 years, the nurse and her family members participated in a big fraud scheme and used fake timesheets, fake patient files, and fake employee files to obtain over $80 million from the DC Medicaid program. Money was used to fund an alleged lavish lifestyle with mansions and expensive luxury vehicles. The investigators in this case included the FBI, HHS OIG, the U.S. Secret Service, the DC MFUCU, the DC Office of the Inspector General, the Office of Labor Racketeering and Fraud Investigations, and several other state and federal law enforcement agencies. It was a very, very big case in DC. 25 individuals ended up being charged for participating in the schemes, including fraud, kickbacks, and false billing. These individuals charged included personal care aides, patient recruiters, and other collaborators. The nurse was sentenced to 10 years in prison, and her husband was also sentenced to 7 years in prison. Very, very significant penalties here. In addition, the judge ordered a forfeiture of $11 million from 76 bank accounts. The residents were approximately $1,073,000 in cash that was seized from the residents, and 5 luxury vehicles with a total purchase price of more than $400,000. The judge also imposed a forfeiture money judgment of nearly $40 million on both defendants. Both defendants were also ordered to pay over $80 million in restitution to DC Medicaid. So this is a pretty egregious case, obviously. You know, creating fake patients, fake timesheets, fake employee files, that's a pretty severe fraud case. So it's not going to come from your everyday, chart audit necessarily. This is a pretty big fraud scheme. But again, it's important to know that these things are out there, and because of cases like this, the government has a lot of concerns about what goes on in personal care agencies. So again, personal care agencies will continue to be under the microscope as they continue to conduct cases and have results like this where they find this type of conduct going on. Next slide. Okay, so responding to audits and investigations, half-truth, lies, and audio tapes. The FBI is somebody who can show up to conduct part of the government investigation. They can show up at your office and want to talk to you. And it's always interesting because the world of law enforcement has advanced in many ways, but the FBI has not. We've seen over recent years, there's been a significant increase in the use of body cameras, for example, by police officers. They're using those cameras when they're arresting somebody. And in some instances, those cameras have been used to exonerate defendants. In other cases, the body cams have solidified government's case against individuals. While several street-level law enforcement officers have generally accepted body cameras, the FBI has remained steadfast in its commitment to avoid tape recording an interview unless certain requirements are met. And on the screen here, we have an FBI form 302. So this is an example of a document that the FBI agents put together after they interview somebody. And why don't they tape record an interview? If you are interviewed by the FBI, typically FBI agents are going to work in pairs. Two people are going to show up to conduct an interview. They will take notes on the interview on this form, on the FBI form 302. They have two people there, so they've got a witness for what they're taking notes on and saying happened. But there's not going to be any sort of tape recording or video recording to prove this summary wrong. It's going to be your word against two FBI agents who put these notes together, and you're not going to get an opportunity to review them, and until your lawyer's looking at them in the middle of your case. At trial, a jury is supposed to give weight to the version of events that's documented on this FBI Form 302. And like I said, since they typically work in pairs, it can be very difficult to overcome the version of the facts that's documented here, because they're going to think that the FBI agents, they seem like they are ethical, and obviously in most cases they're ethical individuals, but it's going to be very difficult for you to disprove the information that's on that 302 because it's your word again against two government officials who prepared that document. And with that in mind, it's important to think about, what would you do if an FBI agent showed up to your office and wanted to talk to you, or showed up to your house and wanted to talk to you. So it's important to think about how you would respond in that situation. And we can go ahead and go to the next slide. So with that said, what should you do? That's always the question. What do I do? You cannot lie to a government agent or an investigator. Can they lie to you? Yes, they can. If the police, the FBI, or an OIG agent lie to you during questioning, it does not render any statements. It does not render any statements against interests that you make involuntary or inadmissible. The Supreme Court has actually addressed this issue in the landmark U.S. Supreme Court case Fraser versus Cupp. A homicide suspect was interrogated by the police and falsely told that an accomplice had already implicated him in the murder. Based on this lie, the suspect confessed to the murder. The Supreme Court subsequently ruled that the use of trickery and deceit can be permissible depending on the totality of the circumstances, provided that it does not shock the conscience of the court or the community. So obviously the question from here is, well, what do they consider to shock the conscience? And I've got some examples of that for you. So for example, an investigator cannot lie about his identity and introduce himself as a defendant's court-appointed attorney. That would be considered to shock the conscience. An investigator who poses as a clergyman in an effort to obtain a confession under the guise that it would constitute behavior that shocks the conscience. Obviously, that having somebody pose as a clergyman and you're then confessing your sins to this person, that would shock the conscience. You wouldn't think that that somebody would be tricking you in that situation. That's a person that you're supposed to be holding with a very strong trust. But over the years, courts have upheld countless confessions, even though the investigator lied to the defendant during the interview. So it's important to know that it's only in really extreme situations where it would be considered to shock the conscience. So it is possible that these agents could lie to you to try to solicit information from you. The government kind of takes the position that criminal activity is such, and we got a quote here for you, is such that stealth and strategy are necessary weapons in the arsenal of a police officer. The mere fact of a deceit will not defeat a prosecution because there are circumstances where deceit is really the only practical law enforcement technique available. So the government is kind of taking the position that sometimes they have to trick the criminals into confessing information. They need to be able to utilize that if necessary, as long as it does not, again, shock the conscience. And so knowing that, FBI agents could show up and they could, they're going to make their own summary together of what the events that occurred. There's not going to be a recording. They could potentially lie to you. It is very important that you engage skilled legal counsel if you're in a situation where the FBI shows up at your house. You can, invoke your right to counsel. You can invoke your right to not incriminate yourself under the Constitution. If they still, you can ask if they have a subpoena, they can't just come into your home. If they still insist on coming into your home or your office, you want to get their business card. You want to call your attorney immediately, but you need to allow them to come in still. Allow them to come in. I would limit what you say to them. I would get your attorney on the phone, and again, I would say, I want to invoke my right to counsel. But again, you don't want to, resist them coming into your home. I would allow them to come in, but I would engage counsel, especially before you talk to anybody. Okay, next slide. I like to provide this example for providers. So many providers and many people always think that if you can just talk to somebody, you can explain what happened. It's very important to know that these people are very skilled investigators, and they are going, anything that a provider says to an investigator, or that you as a personal care owner says to an investigator, you're a subject, you're being interviewed as a potential subject of a crime or a civil fraud investigation. Anything you say can be used as evidence against you in that investigation. Anything an attorney says on your behalf is an argument that's used in that investigation. So an example that we have is that a misstatement or a hyperbole or an exaggeration that can result in prosecution, it can be used against you. There was a case out of Spokane, Washington, where the government conducted an investigation of the controlled substance prescribing and billing practices of a licensed authorized healthcare provider at a local clinic. In the press release that the government released in connection with this investigation, they had this quote that we have on the slide for you. And they said that when the FBI and HHS OIG interviewed the healthcare provider during its investigation, he falsely stated that 99.99% of the time, he checked the vital signs of a patient before prescribing opioid medication. In truth and in fact, as the healthcare provider well knew, that statement was materially false when made because he did not check the vital signs of a patient 99.9% of the time before prescribing an opioid medication. Indeed, the rate at which the clinic performed complete physicals was materially lower. So, in talking to somebody, we use the term 99% of the time, all the time. And clearly the provider said 99.9% of the time because he likely meant, well, not every time, but most of the time, I'm checking. But that statement was used against him in this prosecution to say that he gave us this specific percentage, and that's not what he did when we looked at the actual notes and that were provided. And in this case, it was interesting that the government actually did not charge the healthcare provider with any billing-related violations. They also did not charge the healthcare provider with any controlled substance or opioid prescribing violations. They instead only charged the defendant with making a materially false statement to the FBI. So they held that this 99.9% of the time was a false statement because the provider held himself out to the fact that 99.9% of the time he did something. And when they reviewed those charts, that was not indeed what happened. And that is what he was charged with violating. Not with any billing violations, not with any controlled substance violations. So very important to be very careful when you're talking to these investigators and to make sure you are represented by counsel so that you don't find yourself in a situation where you have made a statement that can subsequently be used against you in an investigation. And because of this, the defendant in this case was facing a potential sentence of 5 years in prison and a fine of $250,000. So, really steep for, a hyperbole or an exaggeration that he made in a conversation with investigators. Next slide. So we have some final thoughts for you here, and then we'll see if we have any questions. Self-audits are not just encouraged, they are required. The company wants to be viewed as a good corporate citizen. And honestly, if you are a personal care agency in Texas and you're working with Texas Medicaid, you are required, you have attested that you have a compliance plan in place, and a component of an effective compliance plan is internal monitoring and auditing. So if you are not doing those, you are really putting yourself at significant risk, not only for billing errors, but you're attesting that you're operating a compliance program, and that's one of the most important components of a compliance program. So you could potentially be allegedly violating your Medicaid agreement with the state. So it's very important that you do that, and that's one of the best ways to protect yourself is to do internal audits. Review those charts. If you identify an issue, you need to return the money to the payer. If you were not entitled to receive that money, it's not your money, it's the government's money. You don't want to subsequently, have an investigation where that is discovered. That can be considered a reverse false claim. And it's much better for you to identify that potential overpayment and return it to the government than to have the government identify it. Because the government will likely uncover other issues in addition to the one that you identified. And from the cases that we work on, we honestly see that when a provider is working to be a good corporate citizen and identifies a potential overpayment and makes efforts to repay those to the government, that is generally favorably looked upon by payers. They appreciate your efforts at being attempting to be a good corporate citizen. Again, billing errors and overpayments must be promptly investigated and returned to the appropriate payer. There are ways to do that. It's important that you make sure that any federal dollars are returned within 60 days of identification. You typically have 6 months to do an internal review. Once you realize there might be an issue, 6 months to investigate, and then 60 days to report and return that overpayment under the False Claims Act. You do need to make sure you're making repayments to all of your payers, especially ones where there's federal dollars involved. But I would always start with traditional federal payers and then move on to your managed care plans. You need to make sure that your staff is properly qualified and that you're screening your staff to ensure that they aren't on any exclusion lists or deemed ineligible to provide care. This is really important. And if you're not screening for exclusions monthly, that's a big problem. You need to make sure you're not just doing it when they're hired, you're not just doing it annually, you're expected to be doing it every 30 days, and it's all of your employees. And one of the areas where we see a lot of individuals where there's a violation that a person is excluded, it's in personal care. So it's not enough just to do a criminal background check. You need to do the exclusion screening. There are companies that can do it for you, but it's very, very important that you are handling that and that you have documentation of those searches that you do every month to defend yourself later on if you do identify an issue. Sometimes people have prior names and you can show, well, I ran all of these names, I did everything that I could to try to make sure that we weren't employing somebody that was excluded. And you also need to make sure, obviously, that they meet all the requirements to be a personal care aide or personal care attendant. You need to promote good relations with your staff, including providing them with an opportunity to internally voice compliance concerns and properly address any concerns raised. This is another major component of an effective compliance program, is to educate your staff on things that they need to be aware of for compliance, and then give them an opportunity to communicate concerns. And then once you are aware of concerns, to investigate and resolve those concerns and keep documentation of what the investigation entailed and what the resolution was. These are all components of an effective compliance program. And if your staff is being educated and being given an opportunity to speak their voice and feels that the company is taking their concerns and compliance seriously, you're going to be in a much better place. Again, like I said before, many of the False Claims Act investigations that we see have whistleblowers who truly care about compliance, and they feel like their company is not listening to their concerns and that they don't have anywhere else to go. They're not just in it for the potential money that they can get back through a False Claims Act case. They are legitimately concerned. They're concerned about the Medicare trust fund. They're concerned about those federal dollars, taxpayer dollars, and they feel like their company is taking advantage. So it's very important that you give them the opportunity to communicate that information and that you take it seriously and that you follow up with them to tell them how you dealt with the issue, what your findings were, and this was the resolution. Always, if you are in doubt on any issue, on an audit or an investigation, on a compliance question, please ask a qualified healthcare attorney for support. There are so many issues that come up in day-to-day healthcare operations, and we know that The rules are constantly changing, so it's very important to have a reliable, qualified healthcare fraud attorney that you can turn to for assistance in these types of issues. And I think that's it. If you want to go to the next slide, Gio, and see if we have any questions.
There's no questions at this time.
Okay. Well, my information is on the screen here. Please feel free to reach out to me via email or phone. Alex and I really appreciate you all joining us today. It's been a pleasure chatting with you all, and I look forward to hearing from you all if you have any follow-up questions via email or phone.
Thank you, everyone, for joining.
Yeah, that concludes today's webinar. Thank you for joining us. And for speakers, Ashley Morgan and Alexander Naum. Everyone from today's webinar will receive copies of the presentation tomorrow via email. If you have any further questions, like Ashley said, please feel free to contact her or directly to us, to Lyles Parker. Other than that, have a good Wednesday and take care, guys.
Thank you.